At the beginning of this seminar, I indicated that criminal procedure split up pretty neatly into two big categories, issues that involve the exclusionary rule and those that don't. In this video, we look at those parts of criminal procedure that don't relate to the exclusionary rule. And here, the material splits up quite neatly into rights that are pretrial, rights that vest at trial, and rights that relate to issues that arise after a trial. So first, we begin with pretrial criminal procedure issues. The first of these is bail. And it's worth noting that the Eighth Amendment has not been applied to the states via the 14th Amendment. It's a small detail, and almost all states have rights to bail written into their constitutions. Next, a criminal defendant in a felony has a right to a preliminary hearing to establish that defendant's probable cause to sit for trial. And here, the most common issue that arises out of preliminary hearings is this. We've got a witness who testifies at a preliminary hearing. That witness is not available at trial for one reason or another, and the issue becomes, can the preliminary hearing testimony be admitted? Answer, typically yes, assuming that the witness was cross-examined by defense counsel who would have the same motivation to cross-examine that he or she would have at trial. Another issue relating to pretrial criminal procedure rights is grand juries. Grand jury issues are not commonly tested either on the essays or on the multi-state, but it's worth being aware of what a grand jury is. First, grand juries operate in secret. The public doesn't have access to what goes on at the grand jury until the grand jury has something it wishes to communicate to the public. Someone who is called before a grand jury has no right to counsel and is not Mirandized, although it is true that one who testifies before a grand jury does have the right to assert his or her Fifth Amendment rights against self-incrimination. But if you'll recall from our brief video on the Fifth Amendment and criminal procedure, should the prosecution choose to extend immunity to a witness, that witness will have to testify in front of the grand jury, really with no holds barred and no questions being illegal. That witness has to testify fully. Also remember, at a grand jury, a witness does not have a right to exclude evidence, nor does a suspect have a right to exclude evidence, nor do people typically have the right to challenge a grand jury subpoena. All right, that's enough for grand juries. One issue that is woven through criminal procedure are the rights and duties of prosecutors. And both before trial and during trial, a prosecutor has got a duty to reveal exculpatory evidence to the defense. And this is an area in which prosecutors naturally have an inclination to play a little hard and fast with the rules. And so when evidence comes out later, after a conviction, that the prosecutor was aware of, not only does the defendant get a new trial, but the prosecutor may face ethics issues. And some states will test material in a crossover fashion, and in states that do that, criminal law and procedure and professional responsibility commonly are crossed over together, not just because the prosecutor has special duties, but also because defense lawyers have particular difficulties that relate to professional responsibility as well. Remember also that before trial, the defendant must be competent, or else a trial can't take place. And this relates in a sort of oblique fashion to an insanity defense. A defendant can assert that he or she was insane at the time the alleged crimes were committed, but if that defendant has not become sane for trial, there won't be a trial because the defendant must be competent to stand trial. Also remember that before trial, a common issue that arises is pretrial publicity. Suppose we've got an especially heinous crime committed in a small community. It's common that a defendant will claim that he or she can't get a fair trial in that small community. And the right to an unbiased jury pool is an important right of a defendant. So changes in venue, in other words, moving the case to a different courthouse, often are necessary in order to afford the defendant a fair trial. Okay, that's enough for considering pretrial non-exclusionary rule criminal procedure issues. Next we turn to rights that are related to a trial. And the first of these rights is both the criminal defendant, and the public at large have a right to a public trial based on the 6th and the 14th Amendments. And the idea is that public trials inherently are more fair, more honest, and the fact that the public has a ticket gives all of us a chance to ride herd over the criminal justice system and to judge how fair and adequate it is. Also, the right to trial by jury is testable here in criminal procedure in a way that it also can be tested in civil procedure. But the issue is much more important and much more commonly tested here in the law of criminal procedure. Remember that a criminal defendant has a right to a jury only for serious offenses, and here we define seriousness based on the possibility of a criminal defendant doing more than 6 months of time in custody. That triggers the right to a jury. Now, how unanimous does that jury verdict have to be? The smallest jury that is permissible constitutionally is a total of 6. If we've got a 6-person jury, that jury must vote unanimously in order to convict. If we've got a 12-person jury, it doesn't offend constitutional standards for a majority requirement of 9 votes out of 12 to be good enough for a conviction. With regard to juries, also keep in mind that a defendant has a right to be tried by a cross-section of the community. And although it is not commonly tested, it's also true that the prosecutor has got a right to an ethnically balanced jury. So if a criminal defense lawyer starts kicking off everybody from a jury that's a member of a particular ethnic group, by and large, a prosecutor is going to have a right to complain about that. And although it is true that the greatest concern that we have in criminal procedure is that the defendant receive a fair trial, it's also true that the prosecutor has got certain rights as well, and the right to an impartial jury, that is a cross-section of the community, is one of them. Also keep in mind that sometimes a trial can be bifurcated, and that the guilt or innocence phase can happen first, and that sometimes a penalty phase is heard by an entirely different jury. We are entitled, both sides are entitled, to have a jury with an open mind. So, where we have a juror that has a moral objection to the death penalty, who feels the death penalty never should be applied to any convicted defendant, under those circumstances, a person with strong anti-death penalty feelings the people have the right to exclude that person from a penalty phase. And if the same jury will consider guilt or innocence that will consider penalty, then we, the prosecutor, will be able to kick off anti-death penalty people from the guilt or innocence phase as well, where there's only going to be one trial. With regard to rights at trial, one right that is not commonly tested, but which certainly has come up, is the Sixth Amendment right to competent counsel. And this is a right that a criminal defendant has got. And there are a number of cases on the record which are fairly depressing to have a look at, where a criminal defendant is on trial for his life and his lawyer is asleep, not calling witnesses, literally asleep, and failing to provide any kind of a defense. Well, those are easy cases to decide. It's obvious that a criminal defendant has a right, when on trial for his life, to have defense counsel who's awake. But more subtle issues arise where the defense lawyer makes decisions that we want to second-guess afterwards. If a criminal defense lawyer has made certain trial tactics that result in a conviction that likely would have occurred anyway, it's unlikely that the Sixth Amendment will afford a criminal defendant a right to a new trial. But the more eccentric the behavior of the defense lawyer, the less zealous it is, the more likely it is that a criminal defendant will have a valid Sixth Amendment objection to the competence of counsel at trial. Another right that criminal defendants have is a right to a speedy trial. And this law is also fairly complicated, and it's also not tested very often. But there are a couple of details that will be in your interest to be aware of. Remember that the right to a speedy trial doesn't attach. The clock doesn't start ticking until charges are filed. And after that, the mere fact that excessive time has passed by itself probably isn't enough to trigger the right to a speedy trial in such a fashion as to invalidate that trial. but the defendant must show prejudice as well as an extensive delay. And on an essay or a multi-state question, what you've got to do is evaluate the facts. How long is the delay? What prejudice has the defendant suffered as a result of the delay? To the extent that the defendant can show both the excessive passage of time and a prejudice, the defendant is likely to prevail. This issue can get a little tricky. Take a careful look for it when you're practicing. With regard to the rights at trial, the prosecutor, again, must disclose exculpatory evidence, and in the real world, sometimes exculpatory evidence doesn't come to the attention of the prosecutor until the middle of the trial. And here, although the prosecutor also is seeking to be a zealous advocate, the prosecutor has an obligation to turn over evidence that it uncovers that would tend to show that the defendant is not guilty. Remember also that the prosecutor bears the burden of proof in a criminal case, and that burden of proof is beyond a reasonable doubt. So a prosecutor must prove each element of each theory of liability beyond a reasonable doubt to be entitled to a conviction. Obviously, it's a higher standard than is present in civil court, but the structure of our reasoning remains the same. Also, jury instructions have got to be fair to both sides, but obviously we are particularly concerned about doing something that would be unfair to the defendant. Finally, with regard to guilty pleas, something that happens typically before a trial or sometimes during a trial, that plea has got to be voluntary and intelligent, and the waiver of rights has to be done on the record, and it also has to be voluntary and intelligent. And this is an area in which really the law is not all that complicated, but the facts in a pattern can be fairly tricky. So as always, you've got to read carefully. And that's enough to consider crim pro issues at trial that don't relate to the exclusionary rule. Finally, let's turn briefly to consider post-trial criminal procedure issues. Obviously, they don't relate to exclusion. By far, the most commonly tested of these issues is a defendant's right to avoid double jeopardy. Once a defendant has been acquitted of a charge, the defendant cannot be tried again, except for separate sovereigns, where we've got a state prosecution that results in an acquittal, and the federal judicial system wants to get involved. That's not a violation of the right against double jeopardy because different sovereigns are trying the case. Remember also that jeopardy attaches at the time a jury is sworn and not before that. If we've got a bench trial with no jury, then when the first trial witness is called, jeopardy attaches. Now, suppose we've got a mistrial. Why do we have mistrials? Well, because something has gone astray during the trial that requires us to sort of hit the reset button and start over again. A mistrial and then restarting the trial is not considered double jeopardy. And the reason for it is typically a mistrial benefits the defendant. But even where a mistrial is called as a result of some mistake or misconduct on the part of the defense, that's not double jeopardy, and the people have a right to try that case over again and get whichever result they're going to get. Remember also that principles of res judicata and collateral estoppel, most associated with civil procedure and civil litigation, also apply to some extent in criminal court. It's a tiny little detail, but it's conceivable you could see a question that touches on it. Remember that the Eighth Amendment is testable on criminal procedure law, and what we're concerned about there is cruel and unusual punishment. So remember, automatic death penalty statutes, where a defendant can be subject to execution really without any stopping or consideration, that's not going to be valid. The death penalty obviously is the most serious form of punishment available in any judicial system, and we try to take great care to make sure that it is exercised in as reasonable a fashion as possible. And finally, the last issue related to post-trial criminal procedure rights that don't have anything to do with the exclusionary rule are appeal, the right to appeal. Remember that the appellate court only has the power to require a retrial. And remember also that the appellate court can only order a retrial for the defense. The prosecution doesn't have a right to a new trial if the defendant has been acquitted. And then the very last issue, once we've got a defendant who has exhausted his or her rights to appeal and is properly convicted and properly sentenced, at that point, remember that the Eighth Amendment still protects that convicted defendant against cruel and unusual punishment. Well, that wraps up a consideration of all of the law of criminal procedure. Next, we will turn our attention to the hypotheticals. And I think you'll see, by the time we're done with the hypotheticals, you've had a very solid chance to review a substantial amount of the material in the outline. As you go through, both doing multi-state practice and essay review, make sure that you annotate your outline with the additional details that you weren't aware of before. That's the way that you will best reinforce your knowledge and bring the most expertise possible when it's time to sit for the exam.